All right, hey, so welcome back. Hey, so we're going to continue on with our contract, and we're down to paragraph 18, which is called standards. Now, in this, I hope to cover paragraph 18, standards A through F, which is different things. It's basically going to cover some different definitions. Now, what you want to be sure to do is read these carefully, well, let me start with letter A, because in letter A, it's title evidence, restrictions, easements, and limitations. You need to read through this carefully. However, I don't want you to become an expert in this because you need to be aware of the time frames that are available for the buyer to review the title and what the what are the means of correcting title defects and how long they have to bring those up and the curative periods and so on and so forth. So what happens is normally when a buyer is using financing, then the lender is going to get involved and take a look at the title policy, which is all well and good. However, you don't want to make you as an agent are not prepared or not qualified to make any recommendations on title and so on and so forth. So what you need to do here is if someone has a question on this, you need to refer them to their own legal counsel to do it, or hear it directly from the title company's office, or if you're using a title company that has an attorney connected to it, which is highly recommended, by the way, then you can talk to them about that as well. So here in this first section, paragraph 18A, title, and then in subparagraph 1, title evidence, it goes through some different things about how soon the title commitment needs to be received, how long people have within time frames once they receive that, if there appears to be a defect on that title policy, and so on and so forth. Okay, so when you read through this, make sure your buyers understand that what a title commitment is. It's a title commitment is basically showing, hey, look, what is the issue or what is the kind of opinion of the title here, and title insurance ensures that. However, the title commitment needs to be clean enough so that they can, the lender will be willing to lend, and you want to make sure that there aren't clouded titles, meaning that there's a question on either who owns it or if it wasn't a prior lien was not cleared properly, and so on and so forth. So this is a pretty loaded section in here, starting with subparagraph 1. But it goes through these different things that can be done. Now, the key here is that none of these prevent use for residential purposes. If there exists at closing any violation of the items B through F, then the same shall be deemed a title defect, right? So if there are things that are a problem, then that's a title defect. And then earlier in the contract, it references what happens when there is a title defect. Marketable title shall be determined according to applicable title standards, so on and so forth. Again, if there are issues here, it needs to be probably reviewed by somebody's attorney, meaning the lender's attorney or the buyer's attorney, especially if they're a cash buyer. You got to highly recommend that they have a lawyer take a look at the title policy and the title commitment to make some recommendations on that. I did the same thing when I recently purchased a home. I wanted to make sure, so I hired an attorney that's familiar with it to take a look at the title evidence to make sure everything was good to go. Once you have that receipt, once you've received the title commitment, the buyer shall have 5 days to notify the seller if there are any items that make it unmarketable. All right, if the seller provides a title commitment is delivered to buyer less than 5 days prior to the closing date, buyer may extend. Okay, if the seller provides the title commitment and it is delivered to the buyer less than 5 days prior to the closing date, then there can be an automatic extension built into there. There is a seller right to cure if once they're made aware of any defects, and the seller has 30 days to cure those defects once they've received evidence of such. And then if the seller cures the defects within the curative period, the seller will deliver written notice to the buyer, and the buyer will have 10 days from the time that they've been notified it's cured to close the deal. If they're unable to cure it, then they'll have to notify the buyer, and then if they do, then the buyer has these 3 choices down here. They can extend the curative period, they can elect to accept the title with with its defects, or electing to terminate the contract and receive a refunded deposit. So notice here that the extending the curative period shall not anything to exceed 120 days. Once again, you are not, if you get to this stage and you're having issues in here, then you make sure that the buyers have an attorney involved, either representing the lender or themselves or both. Okay, so read over that. There's timeframes involved there, making sure that you, if you're representing the seller as well, that if you're choosing the title company, that the title commitment is given in a quick time period. So then, therefore, these dates, if there are any issues, they can get resolved quickly. Survey. Now we're on to B, because we were A and B. If the survey discloses encroachment to the real property, means somebody built a fence or a pool, or God forbid, something immovable like a pool or very hard to move, that encroaches onto another property or is encroaching onto this particular property that you're buying, those things that you need to know, and those would be considered a title defect. And it talks about ways that can go about curing here in there. Paragraph C talks about ingress and egress. It just basically says the seller represents that there is the ability to get in and out of the real property, i.e. the plot that is being sold. Lease information. Sellers shall, at least 10 days prior to closing, furnish the buyer estoppel letters from the tenants, occupants, specifying nature and duration of occupancy and rental fees. So if you're buying something that currently has a tenant in it, or if you're selling something that has a tenant in there, then no later than 10 days prior to closing, you've got to provide the new buyer with a copy of the lease, letting them know how long it's been done, or how long the lease exists. By the way, just a quick heads up, we see this on occasion. Realize that a lease outlives a contract, meaning that just because a seller sells a property, if the tenant has a leaseholding right to that property for another 9 months, let's say after closing, then the new owner has to honor that, or has to get something in writing from the current leasehold owner, meaning the tenant, to say, hey, look, we're going to terminate the lease or whatever. And again, it's not at the new buyer or the new buyer's discretion. It's, based upon it's based upon whether the tenant wants to let them out or not, because they do not have to let them out. So, and extend it. So the new owner is obligated to that lease, is what I'm telling you. So all that has to be there. And it talks about what happens if you don't have a proper affidavit, and so on and so forth, and everything going through that, and what the estoppel letter would look like. Estoppel letter being, who has a right to this property. Goes through that. So, matter of fact, let's read this. If the estoppel letter or seller's affidavit, if any, differ materially from the seller's representations and lease provided pursuant to paragraph 6 earlier on when they provided, or if the tenant occupant failed to refuse or refused to confirm seller's affidavit, buyer may deliver written notice to seller within 5 days receipt of information, but no later 5 days terminating the contract. So if the seller promised something early on in the contract and the estoppel comes back and then it says, no, you said the lease was over in March, and the estoppel comes back and says the lease is not over until September, then the new buyer has the right to cancel the contract if it differs from what they were told. All right? Liens, seller shall provide or furnish to buyer at closing any affidavit attesting to the absence of any financing statement, claim, or lien or potential lieners known to the seller. They can't hide these different things, can't let us know that there are 3 other mortgages on this thing and try and hide the fact and hope that the title company doesn't find them out. If they also can't indebt the property or lien the property in between the time of contract and time of closing. So they have to make sure that all that is in, and that's buyer protection is built in here under liens. F, here's is important to know. Time, calendar days shall be used in computing time periods. Time is of the essence of the contract. Calendar days is, and so when we say 10 days, it's 10 days, right? It's not anything else. 10 days. Sorry about those pop-ups. 10 days means 10 days, 10 calendar days. The only exception to that would be is earlier, all right? Or we can read it here, other than time for acceptance and effective date is set forth in paragraph 3. Any time periods provided or dates specified in the contract, whether pre-printed, handwritten, typewritten, or inserted here, shall not end or occur on a Saturday, Sunday, or national legal holiday. So if a 10-day time period, let's say a home inspection, ends on a Saturday or Sunday or national legal holiday, it extends to 5 p.m. the following business day. By the way, this is the only time 5 p.m. is mentioned. Other than that, the time frames reference a day would end at 11:59 p.m., but only when we have an automatic extension built in. But it says, other than time for acceptance and effective date. That means you can have a time for acceptance and an effective date on a Saturday, Sunday, or a national legal holiday. You just can't have a time period, whether it be a financing, loan approval deadline, a home inspection deadline, so on and so forth. If it falls on a Saturday, Sunday, national legal holiday, it will default next to the following business day. Well, that wraps up paragraph 18, subparagraphs A through F. Kind of loaded in there some stuff. F is important with the time periods, and A is important with titles. So hope that helps.